Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Janice Carney, and Janice is an attorney with her own law practice called Carney Elder Law in Saratoga, California. She received her JD degree from the University of Santa Clara Law School in 1990, and Janice has been practicing law independently for over 25 years. She has been a certified specialist in estate planning, trust, and probate law by the State Bar of California Board of Legal Specialization since 1995. In 2005, Janice became the first certified elder law attorney in Santa Clara County through the National Elder Law Foundation and became only the 8th attorney in California to be recognized as a specialist in elder law by the State Bar of California Board of Legal Specialization. In 2009, Janice became one of the first accredited attorneys by the Veterans Administration in this area. Now, this interview today is the second of a three-part series about the elder care journey, and we're discussing California's End-of-Life Options Act. Janice is a California attorney, and I am a California CPA. This is a California law that we're talking about. So if you aren't a California resident, you're going to have different laws related to this issue. This is only an introduction to an area you should discuss with your own attorney. Janice, thanks for joining me today.
You're so welcome.
Okay. Well, some people have heard some buzz, I think, about this in the last couple of years, but what is this End-of-Life Options Act?
So you might think of it more commonly, what's more commonly thought of as the right to die laws. We're the fifth out of now 6 states to have passed such a law. Colorado just passed it in November. Our law was passed last year in 2015 in October, and it actually did not become effective until June of 2016.
Okay.
It is an act that allows terminally ill patients who have a diagnosis, a terminal diagnosis with a prognosis of 6 months or less to live to request and take a drug to end their life at the time that they choose. It has been very controversial, as we all know, and because of that, it was created in California as a temporary law. So this law will actually sunset in the year 2026, so about 10 years. And we'll give it a try and see if it works here in California.
Yeah.
So that's in essence what it is.
Okay. So who can use this?
So you have to be an adult in California. That means 18 years or older.
Okay.
And you have to be a California resident.
Okay.
So that's one of the big issues, is that people who wanted to use, say, the Oregon law or state of Washington law had to move to Oregon or Washington and become a resident there in order to use their end-of-life option. Today, they can stay here in California and be able to take advantage of this. You have to prove you're a resident in one of 4 ways that the Act actually outlines, but they're the typical kind of ways: the driver's license, voting in California, owning property or leasing property here. So that's
Show a utility bill?
I think actually that is one of the ways to show residency here. So you can do that. Paying California taxes could also get you show you residency. So that would be an adult California resident. I mentioned before, you have to be diagnosed with a terminal illness, and you have to have a prognosis of 6 months or less to live. In fact, you have to be diagnosed by 2 physicians as having this terminal illness and the prognosis of 6 months or less, so that there's no there's no question about whether or not that is in fact true. Of course, who knows how long somebody's actually going to live, Michael? I mean, you know, the doctors might give you 6 months and you live 6 years. We hear those kind of stories all the time. So it's got to be to a reasonable certainty that the doctor in good faith thinks that's their medical opinion.
Okay.
So,
so who do they think? Who do they think is actually going to use this?
Well, we can look at the Oregon, who's had the law since 1997, so 9 years now. And in Oregon, it's been about 50-50 men and women. It's been mostly white, mostly higher educated. So some higher degree, or like 40% have a BS or greater. The ages have ranged from anywhere from 25 to 95. So it's the whole range of individuals. It's not necessarily seniors. It's many.
Well, we're saying 25. That's not a senior.
No, not at all. When you think about who can use it, the person who's terminally ill, we're talking and they have a diagnosis of 6 months left to live. The people who want to use it usually are younger, and they have a very painful, very aggressive end-of-life kind of illness, like cancer or Parkinson's and some of the other kind of things. So they're highly educated, great range of ages, but and they're mostly, I think it's like 80% of the cases in Oregon were cancer patients.
Yeah. So we had this young woman from California that I think her family was one of the groups that was really pushing this, and she was fairly young, and I think she had young kids and stuff. Well, but she had a very serious cancer.
Yes, Brittany Maynard is attributed in California. She was the woman that was 29 years old, and she had a brain tumor. And she was out of Anaheim, and she didn't want to leave home, but she didn't want to put herself through the pain or her family through the pain of a drawn out passing. So she was lobbying legislators in Sacramento to pass this. This was in 2014.
Okay.
In fact, she ended up having to move to Oregon because nothing in Sacramento happens fast. We know that. And so she moved to Oregon, and she actually used their act there and ended her life. I think it was November 1st of 2014. Her mother and her husband, though in her honor, continued the campaign, which led to that passage in October of 2015.
Right, okay. Well, what are some of the requirements, again, for using this?
Okay, well, the biggest and most important requirement and the most impactful requirement is that you have to be mentally and physically capable of requesting and taking the end-of-life drug yourself. You cannot authorize somebody to do it for you if you have lost capacity to mentally or physically do this. You have to have mental capacity, and mental capacity in the law generally means that you have to understand what you're asking for, the consequences, and all the kind of ramifications of it. So what are you doing, what do you want, and why do you want it?
So somebody that has severe dementia, for example, probably wouldn't be able to use this.
That's exactly right. So a lot of my seniors, as an elder law attorney, people come to me and they want to write it into their advance directive, and you can't do that because no one can do this for you once you've lost capacity. I actually do add something to my advance directives to say that if I've lost capacity artificially, like I'm in an induced coma or I'm on medications that have I'm doped up kind of thing.
Yeah.
That I want my agent to tell the doctors to bring me up to consciousness so that I can make my own decisions. Not just about whether or not I want to take this kind of drug, but about all of my end-of-life kind of decisions. And that this is not something that I delegate if I have the ability to regain capacity to somebody else. And that could be something that people start thinking about in their advance directives, to say, okay, I want to have this ability to do it. And your agent can help you get there, potentially, but they're not administering or requesting the drug for you.
Okay.
So some of the other requirements are that you actually have to ask the physician 3 times for the drug. You have to do 2 times verbally. Two of the two requests have to be at least 15 days apart, so a couple of weeks apart. And then 1 request has to be in writing. You have to sign it, and it has to be witnessed. Now, you might have a very shaky, you might sign it with an X because you're too shaky to sign it, but that's a legal signature anyway. So it requires 3 requests to your physician, your attending physician. Then the attending physician needs to bring in a consulting physician to confirm the diagnosis and the prognosis and your mental capacity, that you have the ability. If you don't, or they aren't sure, those 2 physicians aren't sure you have capacity, they can let you or refer you to a mental health specialist, either a psychiatrist or psychotherapist, to make the decision about your capacity and determine if you have the ability to understand what you're asking for. In addition, as I said, you have to have the physical capacity. So once you have the drug, you have to be able to ingest it or inject it or ingest it yourself. I don't know exactly what all that means. Clearly, you have to have the ability to swallow. Does it mean that you have to have the ability to pick it up and put it in your own mouth? Maybe not. The Act doesn't say that. So you can get assistance with this. Some of the other requirements of the law involve the counseling that the doctor has to give you and how much the doctor has to inform you. The Act was very, very, very clear and talks about the ability for you to withdraw your request. So they want to make sure that someone who thinks that they might want to do this has all kinds of counseling and information saying that just because you ask for the drug doesn't mean you have to ever take it. The law does require you to keep it in a safe place so that until you ingest it, so that others can't mistakenly take the drug. If you decide that you don't want to take it, you can turn it back in. You don't have to keep it. So there's a lot of safeguards in that respect that the doctor has to inform you about. The doctor also has to fill out lots of different forms, and you have to sign certain forms as well. So those are the kinds of requirements to using it.
Okay. So you started to get into a few of the safeguards. Are there some other ones that people should be aware of?
Sure. The biggest safeguard to this is that it is a felony for someone to be inducing you to do this. So you're supposed to be able to do it completely voluntarily, that if someone tricks you into it or induces you into it, or clearly if they forge your name, or if they get the drug and then they give it to you without you understanding what you're doing, I think that's just plain murder, right?
Okay.
So clearly that's a felony. Some of and clearly people have always probably committed suicide. And so this is, you would think it is suicide. It's not legally suicide. But the difference between suicide and this is the legal ramifications on your state and on the people who have helped in this process. So the medical providers, anyone who might be in attendance with you to help you, they're not going to go to jail over this. Yeah. There is no criminal or civil or administrative or any sort of ramification on the persons who assist you with it if it's done according to the rules legally. Furthermore, if you have complied with the law and have ended your life in this way, your death certificate lists the underlying disease as the cause of death, not self-inflicted suicide. So those are some of the things. Another protection in the law is the protection of people in the medical world. Medical providers can't be required to assist this. So the medical providers can refuse to participate in the program. Medical providers such as hospitals or nursing homes, in fact, have to be creating procedures and policies so that the individuals who work there can each decide independently if they're going to participate in the act or not. And if they don't want to, there can be no ramifications, negative ramifications on their employment and to not doing that. So that's a very important kind of safeguard to it.
Okay. So I think one of the challenges that's come up, you mentioned the thing that, basically doctors can refuse. And so finding somebody that's going to cooperate with you in helping you to do this, I think, that's been a real challenge for people that, that have tried to use this procedure.
Well, that's very true. And I think as time goes by, physicians and other medical personnel will make up their own mind. It may be based on ethical or religious beliefs, but if they feel that this is not contrary to their religion or their ethics, that they may come around to it. There are a few doctors in California already, and there is at least one hospital that I know of, and I'm sure there are more coming online all the time, that have agreed that they will allow this, and they'll help participate in it. There are some organizations online. These organizations, one of them is the Compassion and Choices. There's another one called the Coalition for Compassionate Care of California, another one called California Death with Dignity. And these are all organizations that have online websites that have more information, and they're also, I'm sure, going to be, if you contact them, maybe not online, but contact them directly, they may be able to lead you to others. Even the California Department of Public Health has the forms that you have to complete in the various stages of doing this. So I think that there's going to be resources for people to go to. If your physician elects not to participate in it, they're supposed to give you a referral to physicians or medical providers that can. Now, they might just be referring you to these kinds of organizations, but I think as time goes by, this will change, and that at least they will tell you where to go. And it might be the kind of physician you're talking to. Maybe not your primary care physician, but maybe your oncologist if you have cancer.
Yeah.
Because the doctors who are treating the illnesses that are very, very painful are going to be the ones who are being asked to help with this, or at least they are going to have a network of other physicians that they probably will know who's doing it and who's not. So I think that as time goes by, you'll see this. Also, the sheer numbers in California. In Oregon and Washington, one of my colleagues who practices in Vancouver, Washington, which is right on the border, said that, told me that about 60 individuals in each of those states use the act every year in those states.
Okay.
Well, compare the population in California. We're going to be looking at, hundreds, thousands maybe in California every year that might use this just because of the sheer numbers here. But we'll see. We'll see. And if it does in fact get up like that, then there will be more pressure put on certain physicians or physicians who are willing to do it to participate in this. Clearly, physicians have their Hippocratic oath, and so that they are very concerned about does this make sense?
Yes.
But I think I'm not a physician.
Yes.
I'm not an ethicist even.
Right.
So I think that they are finding their way through this, and certain ones will and certain ones won't. So that will wait to be seen. But if this is what someone wants to do, they're in pain, they have the diagnosis, they have the prognosis, and they have capacity, they will, they will start their search, and I believe they will find physicians.
So just to let you know, we're about where we are. We're about maybe 4.5 minutes left.
Okay.
Okay. So related to this, though, I mean, each of us have had our own experiences. I've had it, in the past several years with my wife's parents passing, my parents passing, and so forth. And so, and particularly talking to the people with hospice. And so basically they raise the issue, are you prolonging life or are you prolonging death? And, I mean, these aren't easy issues, but nonetheless, you have to think about that. If in fact what you're doing is, prolonging suffering for somebody, and again, if they don't have a prognosis for improvement, no expectation of improvement in quality of life, maybe it's the compassionate thing to do.
Well, so every person is going to be making those decisions. I have to tell you, Mike, that as an elder law attorney, I have clients come to me all the time and they say, "Don't worry, honey, I'll take care of that. I'll know it, and I'll take care of that." No one ever has. 25 years of practice, and no one ever has done that. And I believe that as we age, we never think that we're really at the end. Now, my mother-in-law, like your parents or your wife's parents, she woke up every day saying, "Why did I wake up today? I'm so ready to go." And but today's seniors, I don't feel are saying that so much. Oftentimes they say, I will say to someone, "Oh, you'll probably live to be 100," and they say, "Oh, I hope not." But if they were 98, they're probably saying, "Well,
why not?
Shoot, I'm okay. I'm doing okay." So as long as you're not in a great deal of pain, and that you have some enjoyment in your life, I have rarely met the person who is ready to go. Again, this act is for the people who are terminally ill and they're dying anyway. Who's not going to be able to use this act? The person, I think, that needs long-term care. The person who needs long-term care because they're in this slow decline. They either have a medical condition that's not terminal, it's not a 6-month or less prognosis, or they've got, as you mentioned earlier, dementia of what caused by one sort of another, and now they can't use it. So most people at the elder end of their life I don't think will be using this act because they aren't going to qualify.
Uh-huh.
They're purely not going to qualify. So it's more directed towards the person who is younger, had been healthier, is competent, and is in excruciating pain.
Yeah.
And that's where the act is supposed to be directed towards. So most of those seniors who come to me saying, thinking that this is a way to avoid the cost of long-term care, that's not what this act is about.
Right. So what's going on is you're doing a lot of public seminars on this.
I am.
So basically what's happening is that there's a lot of interest or curiosity about it, but then not much action maybe when people look into the details.
Well, there's nothing you actually can do
Yeah.
unless you are in that situation.
Yeah, right.
And then you can talk to your doctor about it, and if the doctor doesn't know anything, there's quite a bit of information online now about it, so you can search there. If you don't find it online, or you're someone who doesn't use online
Yeah.
research, I'm sure that your doctor can give you referral numbers to call, and others come talk to you. A few hospice agencies may be looking at incorporating this, but because by the nature of hospice, you're supposed to have a terminal illness that's 6 months or less to live.
Right.
So if there's a lot of pain, but on the other hand, you might have...
We're out of time, Jan.
Oh.
Sorry to interrupt
Sure.
you. Okay, folks, but we are out of time. So I want to thank Janice for being with us today and let you go. So we'll see you next time on Financial Insider Weekly.